Good morning, everyone. This meeting is called to order. Mr. Trobman, has anyone signed up for public comment? Thank you very much. Good morning, Ms. Miller.
Good morning, sir.
We have no cases to reconsider under agenda item 3. Is that correct?
Yes, sir, that's correct.
All right, let's move then to consider tax liability cases under agenda item 4. I believe we have 2 tax cases on docket 22. Is that correct?
Yes, sir. The first case is TD-19-001-0119. Commissioner Demerson?
I agree with staff recommendation.
Commissioner Alvarez?
I agree with staff's recommendation.
Mr. Chairman?
Agree with staff recommendation.
The second case is TD-19-129-1119. Commissioner Demerson?
I agree with staff recommendation.
Commissioner Alvarez?
I agree with staff's recommendation.
And Mr. Chairman?
Agree with staff recommendation.
Thank you, sir.
All right. We have no fair housing cases under agenda item 5. Is that correct?
Correct.
All right. Let's move to agenda item 6. We have no wage claim cases pulled for additional discussion on docket 22.
That's correct, and you should have received the short form dissent list.
I move we accept staff recommendations on the remaining wage claim cases on docket 22.
I second the motion except for those cases on which I am dissenting, as reflected on the wage claim short form dissent list for docket 22.
I concur with the chairman's motion, except for the cases on which I'm dissenting, as reflected in the wage claim short form dissent list for docket 22.
Motion passes with the exceptions noted.
Thank you, sir.
Let's move to agenda item 7 and consideration of unemployment insurance cases on docket 22. Proceed when you are ready.
Yes, sir.
Case 2455915, Commissioner Alvarez.
The decision should be affirmed. The claimant quit to move with her future spouse. Therefore, a spousal leaving provisions under Section 207.045C should apply. The claimant should only be disqualified for a period of 6 weeks. Affirm the AT decision, spousal leaving, 6-week disqualification, reimburse an employer not billed.
The AT decision should be modified. Section 207.045C should not apply to the facts of this case, since the claimant was not married when she resigned from her position. Because the claimant quit to move closer to her fiancé, she quit for personal reasons and not for good cause connected with the work. We should modify the AT decision, voluntary leaving, reimbursing employer not billed, adequate employer response.
Affirm the AT, quit to move with spouse, 6-week disqualification, reimbursing employer not billed.
Short form dissent.
Yes, sir. I'll short form dissent on the separation since the reimbursing employer is not billed.
Yeah, I agree with the reimbursing employer not billed.
Thank you, sir.
Okay, all right.
Case 2472687, Commissioner Demerson.
The AT decision should be modified. I agree that the claimant did not credibly establish good cause for his non-appearance. Regarding the job separation, this case should be treated as an MVI. The job separation occurred when the claimant stopped performing services for pay after experiencing a serious medical episode. As such, I agree that the claimant's separation was non-disqualifying. However, since the claimant's separation was the direct result of a medically verified illness, this case should be coded under the MVI provisions of the Act. We should therefore modify the AT decision. The claimant did not have good cause for his non-appearance, no voluntary leaving, MVI.
I would agree to that.
I would also agree.
Thank you. It's unanimous.
Case 2472874, Commissioner Alvarez.
Sorry about that.
I thought she knew something I didn't.
I'm sorry.
The decision should be reversed. The claimant was the only party providing sworn testimony. The claimant's testimony established that she was asked to keep a conversation that she had had with the CEO confidential, which she did. The claimant simply told her supervisor that she had been placed on performance improvement plan, which is information that supervisors would need to know. The evidence is insufficient to establish misconduct connected with the work. Reverse the AT, no misconduct.
We should affirm the appeal tribunal decision. The claimant did not follow the CEO's instructions to keep a prior meeting confidential. Thus, the claimant mismanaged her position of employment, and we should affirm the AT decision, misconduct.
Reverse the AT, no misconduct.
Short form dissent.
Thank you. I have a short form dissent for Commissioner Demerson.
Okay.
Case 2475481, Commissioner Demerson.
The appeal tribunal decision should be affirmed. The claimant had brought her concerns to the employer, and the employer investigated. The employer could not substantiate the claimant's allegations. The employer's general manager stated that the claimant did not report any of these concerns to her until close to the end of her employment in October of 2019. The claimant stated that she had been in the running for promotion but did not receive it. The claimant quit her job. As such, the preponderance of the evidence establishes that the claimant resigned due to dissatisfaction with her working conditions without giving the employer an adequate opportunity to remedy. This constitutes a voluntary quit without good cause connected with the work. We should therefore affirm the AT decision, voluntary leaving, no chargeback.
The AT decision is not supportable. The record was poorly developed. While the claimant had ongoing complaints about the work environment, it appears that the two incidents described were later in employment and were an escalation. The record should be developed on the dates of the specific incidents and the dates of the claimant's complaints to management. Accordingly, this case should be reheard.
Rehear.
We'll rehear the case and resubmit it. Next case, please.
2478953, Commissioner Dimerson.
The appeal tribunal decision on timeliness should be reversed. The timeliness rules state that a document mailed to a party is presumed to be received if the document was mailed to the complete, correct address of record, unless there is a tangible evidence of non-delivery, such as the document being returned to the agency by the United States Postal Service, or credible and persuasive evidence is submitted to the agency to establish non-delivery, delayed delivery, or misdelivery of the document. The file documents of this case establish that the notice of maximum potential chargeback was returned to TWC as undelivered. As such, the employer has rebutted the presumption of receipt, and its response to the NMPC, the non-notice of maximum potential chargeback, should be deemed timely. We should therefore reverse the AT decision on timeliness. The employer responded timely to the notice of maximum potential chargeback. Resubmit for merits testimony.
The decision should be affirmed. The employer did not provide a new address to TWC after moving. Therefore, the employer's protest was properly dismissed as late. Affirm the AT decision, late protest, chargeback.
Affirm the AT untimely protest to the notice of maximum potential chargeback, chargeback.
Short form dissent.
Yes, sir. I have a short form dissent with Commissioner Dimerson.
Case 2480681, Commissioner Alvarez.
The AT decision should be modified. I agree with the AT that the claimant had good cause to miss the first AT hearing due to personal illness. On the separation, the claimant worked for the only one day for a ride-sharing service and was unable to continue in the job because it aggravated his back injury. The claimant's medical condition was supported by documentation provided to the Commission. The claimant's separation was caused by a medically verified health condition and should not be disqualifying. Modify the AT. Claimant had good cause for their non-appearance. No voluntary leaving, void chargeback.
The appeal tribunal decision should be affirmed. I do not contest the good cause rulings. As to the job separation, the claimant quit for personal reasons without work-connected good cause. The chargeback ruling should be voided. We should therefore affirm the AT decision. The claimant had good cause for his non-appearance, voluntary leaving, void chargeback.
Affirm the AT. Claimant established good cause for AT1, voluntary leaving, void chargeback.
Short form dissent.
Thank you. I have a short form dissent for Commissioner Alvarez.
Case 2483440, Commissioner Dimerson.
The appeal tribunal decision should be modified. The claimant quit her job due to dissatisfaction with the workplace. The claimant alleged that her supervisor was disrespectful to her and that her concerns were not being addressed. However, the employer explained that there was an unwillingness to assign additional tasks to the claimant based on her job performance. The employer further explained that the claimant was not meeting job expectations. The claimant also made mention of her training her replacement, but the employer explained that this was done so that the employer would have someone to cover the claimant when she was out, and that the employer was not sought to discharge the claimant or end her assignment. Furthermore, 2 email exchanges and file documents between the claimant and her supervisor do not appear to reflect hostility or disrespect. Nonetheless, the employer tried to accommodate the claimant's request for a transfer, but the claimant declined the offer. As such, the claimant quit for reasons other than good cause connected with the work. We should modify the AT decision. voluntary leaving, no chargeback, sever adequate response.
The decision should be reversed. The claimant made repeated complaints to the employer regarding the client's company management of her assignment since July 29 and made multiple requests to be reassigned. The employer failed to resolve the claimant's complaints about the client company and was unable to reassign her. Since the claimant gave the employer reasonable opportunity to resolve her complaints and they failed to do so, the evidence is insufficient to establish that the claimant had work-connected good cause for quitting. Reverse the AT, no voluntary leaving, chargeback, void, adequate response.
Modify the AT, voluntary leaving, no chargeback, sever adequate response.
Short form dissent.
Yes, sir. Short form dissent for Commissioner Alvarez.
Case 2490098, Commissioner Demerson.
We should affirm the appeal tribunal decision. The claimant was discharged for directing an incredibly rude gesture at a coworker. The claimant denied wrongdoing at the hearing, but his credibility was seriously undermined by his admission in a fact-finding statement provided prior to his disqualification. Because the preponderance of the credible evidence established that the claimant engaged in inappropriate, unprofessional, and rude behavior at work while on a final warning for similar behavior, the claimant was discharged for misconduct connected with the work. We should affirm the AT decision, misconduct, no chargeback. In the alternative, because the employer was prevented from providing witness statements and a video of the final incident prior to the hearing due to technical difficulties, we could rehear this case for submission and review of this evidence.
The decision should be reversed. The employer only provided hearsay statements to prove its allegations. The claimant denied the allegations under oath. While the employer testified that they had other witness statements and a video of the final incident, the employer failed to provide this evidence to the commission. Because the claimant has denied the allegations under oath, the hearsay evidence presented by the employer is insufficient to establish misconduct connected with the work. Reverse the AT, no misconduct, chargeback. In the alternative, the claimant is a veteran with PTSD and will agree with the untrue statements to avoid situations that trigger his PTSD. Therefore, the separation is the very least that should be considered to have been caused by his medically verified illness. In the alternative, modify the AT, no misconduct, no chargeback, MBI.
Affirm the AT, misconduct, no chargeback.
Short form dissent.
Thank you. I have a short form dissent with Commissioner Alvarez.
Case 2490125, Commissioner Alvarez. I'm sorry.
That's the way my day's going to be, sir. Can you repeat the number again?
Please repeat.
2490125, Commissioner Alvarez.
The decision should be reversed. The claimant was granted a leave of absence due to the passing of his mother-in-law. While on leave, the claimant's wife died in a traffic accident. As a truck driver who was away from home for long periods of time, the claimant heavily relied on his spouse. Therefore, following the death of his wife, he was unable to continue working as a truck driver for the employer and had to quit. As such, the claimant had good cause to quit and should be qualified for benefits. Reverse the AT, no voluntary leaving, no overpayment.
The AT decision should be affirmed, voluntary leaving, overpayment.
Affirm the AT, voluntary leaving, overpayment.
Short form dissent.
Yes, sir. I have a short form dissent for Commissioner Alvarez.
Case 2490270, Commissioner Demerson.
We should modify the appeal tribunal decision. The claimant was unable to accept the new position she was offered due to limitations related to her chronic medical condition. The claimant further provided medical documentation in support of her decision. Thus, because the record established that the job separation resulted from the claimant's medically verified illness, the claimant should be qualified for benefits and the employer's account should be protected from charge under medical separation analysis. We should modify the AT decision, no voluntary leaving, no chargeback, MVI.
I would agree to that.
I agree.
Thank you. We have unanimous decision.
Case 2490271, 348, Commissioner Alvarez.
The decision should be modified. The claimant was absent due to illness for 1 day. He did not see the doctor for his illness. The employer's policy does not require employees to see a doctor and bring a doctor's note for every illness. The policy only requires a note if an employee misses work for a doctor's visit. Neither the claimant's 1 day of absence nor his failure to bring a doctor's note were misconduct connected with the work. Modify the AT, no misconduct, no chargeback, MVI, void adequate response ruling.
The AT decision should be modified. The evidence establishes that the claimant should have known that he would need to provide a doctor's note upon his return to work. Since the claimant failed to do so, he mismanaged his position of employment. Moreover, I would not agree to an MVI because the claimant was not discharged for his absenteeism. We should modify the AT decision, misconduct, no chargeback, sever adequate response.
Modify the AT, misconduct, no chargeback, sever adequate response.
Short form dissent.
Thank you. I have a short form dissent with Commissioner Alvarez.
Case 2490388, Commissioner Alvarez.
The record in the AT hearing did not support the AT decision. The prior statements to the commission established that the claimant had a number of problems with his pay from the employer. In the AT hearing, the hearing officer did not develop the record about those problems getting paid. The claimant testified that he was underpaid twice, and the record was not further developed on those incidents. The case should be reheard so that the record can adequately develop.
The appeal tribunal decision should be modified. The claimant quit his job due to dissatisfaction with the workplace. However, the claimant did not afford the employer an adequate opportunity to address his concerns. As such, he quit his job without good cause connected with the work, and we should modify the AT decision, voluntary leaving, no chargeback, sever adequate response.
Rehear to further develop the record.
We'll rehear to further develop the record.
Case 2491908, Commissioner Demerson.
The appeal tribunal decision is fully supportable and should be affirmed. The claimant was discharged for tardiness after having been placed on a final warning. The claimant indicated that transportation issues contributed to her attendance issues. Because transportation was the claimant's responsibility, the claimant continued tardiness after warnings constituted mismanagement of her position of employment. We should affirm the AT decision, misconduct, reimbursing employer not billed.
The AT decision should be reversed. The claimant was discharged due to poor attendance. The claimant's final attendance issues occurred when she was in a car accident on the way to work, and the second attendance incident when she was suffering from fatigue and back pain from a car accident. The claimant reported to the employer that she had wanted to use FMLA to cover those two attendance incidents. The employer denied her request under her existing FMLA claim, and they failed to give the claimant the opportunity to file a new FMLA claim related to her injuries from the car accident before discharging her. Since the claimant's final attendance issues were caused by an unavoidable accident and her personal injuries, and she was not given the opportunity to file FMLA claim related to the injuries sustained in the car accident, the claimant was discharged for reasons other than misconduct connected with the work. Reverse the AT, no misconduct, bill reimbursing employer.
Reverse the AT, no misconduct, bill reimbursing employer.
Short form dissent.
Thank you. I have a short form dissent for Commissioner Demerson.
Case 2493149, Commissioner Alvarez.
The AT decision is not supportable. The claimant was living in Indiana at the end of 2019, and he filed his initial claim in that state. He did not know that he should file his initial claim in Texas because that was where he earned his wages. He was notified that he should file his claim in Texas, but he first had to withdraw from his Indiana claim and then wait for Indiana to update its records to reflect that his claim had been withdrawn. The claimant was delayed in filing his claim in Texas through no fault of his own, and he should be allowed to backdate his Texas claim to 12/29/19, which was the date of his Indiana claim. Reverse the AT, grant request to backdate the initial claim to 12/29/19.
We should affirm the appeal tribunal decision. As early as January 8, 2020, the claimant was informed by the state of Indiana that he could file his claim in Texas. We have no record that the claimant contacted Texas prior to filing the current claim. In addition, the claimant did not allege that he was misinformed by a TW representative. Thus, because the preponderance of the evidence establishes that the claimant had the opportunity to file a valid claim in Texas but failed to do so, the claimant did not establish good cause to backdate his claim, and we should affirm the AT decision. Deny the claimant's request for backdating.
Reverse the AT. Claimant's initial claim backdated to January 5th, 2020.
All right, we have a majority vote to grant the backdating, but the dates don't match.
Thank you, Ms. Miller. I'll agree with Chairman on the
Thank you.
backdate.
With the claim
The
date
date
of
of
January
January.
5th, 2020.
Yes, ma'am.
Short form dissent.
Thank you. I have a short form dissent for Commissioner Demerson.
Case 249659, I'm sorry, I'm going to start over. Case 249659, Commissioner Alvarez.
The decision should be reversed. The claimant made a mistake in the course of performing his job duties. The mistake was corrected, and there is no evidence of damage. The employer had progressively disciplinary policy that calls for written warnings and final warnings before termination. There is no evidence that the claimant was given the benefit of the progressive disciplinary policy. Accordingly, the evidence is insufficient to establish misconduct connected with the work. Reverse the AT no misconduct chargeback.
The appeal tribunal decision should be affirmed. The claimant admitted to making an error that caused dysfunction with the employer's computer system. The error resulted in considerable consequences as it affected the employer's financial system. Given the impact the claimant's actions had on the employer's computer system, misconduct was established. We should affirm the AT decision, misconduct, no chargeback.
Affirm the AT. Misconduct, no chargeback.
Short form dissent.
Thank you. I have a short form dissent for Commissioner Alvarez.
Case 2498698, Commissioner Alvarez.
The AT should be reversed. The claimant returned to work during the benefit week ending October 5th, 2019. The Commission requested a work search log for the week ending October 5th, 2019. The claimant notified the Commission that she returned to work and was paid for her waiting week. Under Appeal 2722-CA-77, a claimant with a return to work within 6 weeks is no longer required to search for work. The claimant should not be held ineligible for failing to produce a work search log for a benefit week, during which she was not required to search for work, and during which she had already returned to full-time work. The claimant's appeal should be deemed timely, and the reporting and overpayment should be voided. Reverse AT, deem appeal timely, void reporting and overpayment determinations.
We should affirm the appeal tribunal decision. The claimant has not stated any reason for a late appeal which constitute an exception to the timeliness rules. Thus, we have no jurisdiction to consider the underlying merits. Accordingly, we should affirm the AT decision. The claimant filed a late appeal, reporting not eligible September 29, 2019 through October 5th, 2019, overpayment of $492.
Affirm the AT. Untimely claimant appeal. Reporting not eligible September 29, 2019 through October 5th, 2019. Overpayment.
Short form dissent.
Thank you. I have a short form dissent with Commissioner Alvarez, and that was the last case pulled for discussion. You should have received the short form dissent list.
I move we accept staff recommendations on the remaining UI cases on docket 22.
I second the motion except for those cases on which I am dissenting, as reflected on the UI short form dissent list for docket 22.
I concur with the chairman's motion, except for the cases on which I'm dissenting, as reflected in the UI short form dissent list for docket 22.
Motion passes with the exceptions noted.
Thank you, sir.
Thank you. This brings us to the end of agenda items 3 through 7. Let's pause for a few minutes to reset for the rest of the meeting. Good morning, Mr. Cerna.
Good morning, Mr. Chairman, Commissioners. For the record, Ed Cerna. We only have two updates for you, one from Clay Cole on UI and the other from Courtney Arbor on workforce activities. So we'll start with Clay Cole.
So this is on agenda item 9,
I'm sorry,
which is
yes.
discussion, consideration, possible action regarding guidance on resource utilization and implementation of services and strategies to target disaster relief efforts and public health emergencies, including those funded with the Department of Labor's Disaster Dislocated Worker Grant.
Yes, sir. That's it. Clay Cole.
Good morning, Chairman Daniel, Commissioner Alvarez, Commissioner Dennison, Mr. Cerna. For the record, Clay Cole, Unemployment Insurance Division Director. Quick update on some statistics. To date, TWC's paid out over $9.5 billion in unemployment insurance benefits and closed nearly 4 million assignments. Clearly, we know we have work to do in assisting all those out there that need our services. So we're continuing to really work to make sure we meet their needs. Big update today is this weekend we received official notice from the Department of Labor that Texas is triggered on to state unemployment insurance extended benefits. And under the CARES Act, the Department of Labor is reimbursing states 100% for state extended benefits paid. Now, state extended benefits is an additional 50% of the regular UI entitlement up to 13 weeks of additional unemployment insurance. And this follows the pandemic emergency unemployment compensation period. So TWC could start paying state extended benefits the week ending July 4th, 2020. UI and IT have been working on programming in anticipation of us triggering on. UI and External Relations have prepared a press release we plan to release after today's commission meeting. The extension does not provide additional benefits to those covered under the pandemic unemployment assistance, such as the self-employed and the independent contractors. This is an additional up to 13-week extension for those covered employees that exhaust the pandemic emergency unemployment compensation. UI and IT completed notifying all of our potential PEUC, that's a pandemic emergency unemployment compensation individuals to date. And to date, we've processed over 50,000 PEUC claims. Teams continue to work on plans for Texas reopening businesses and have been looking at ways to expand our self-service opportunities for customers, really to help minimize calls for assistance. And this concludes my brief update, and I'll be happy to answer any questions you might have.
Comments or questions?
Not here, Chairman.
Not
Great
here.
work.
Thank you.
Clay, thank you.
Before we go to Courtney, I would point out something that Clay didn't mention, but we are making a number of outbound calls as well to those customers of ours that we know have an issue. So instead of waiting to try to get people to reach us, we flipped a call center and are pretty much dedicating it 100% to outbound calls. And we're targeting those areas that seem to be issues with our customers, and increasing issues with our customers, such as back pay or still trying to get a start date set up. So
Great.
So now we'll do Courtney.
Thank you.
There's Courtney.
My update, Commissioners, if you're ready.
We're ready.
Ready?
Okay. On April, good morning, Commissioners. Courtney Arbor, Workforce Division, for the record. Wanted to give you an update on the funding that was approved on April 14th for COVID response, and an update on the four funding streams that were approved that day. Adult Ed funds, as you know, were approved to support distance learning. And with that, providers have procured distance learning licenses to expand classroom training in this new environment. Every adult ed provider does offer distance learning, and with this, they've been able to expand that. I know you wanted some details today, so I'm going to go into a little detail about numbers and dollars spent on activities. $167,000 has been spent for licenses. That builds out the capacity for online testing also, which was about $53,000 was spent for that. You're aware that not only do we need to provide classes virtually right now, we also need to ensure that students can test. That was a challenge early on, and the team has worked across the state with vendors and our providers to ensure that testing is now an option. So we've got the funding spent both on testing, some on staffing as well, but with the primary use of the funds for distance learning licenses. And I will just congratulate our adult ed providers for really rising to the occasion here and expanding services to make sure that students have options. With the up to $10 million in skills development funding approved, 37 applications have been received by TWC from colleges and boards, totaling $6.2 million in funding. The awards support an estimated 3,802 trainees now through July 2020. The training will be ongoing, but just wanted to give you an idea of kind of the training that's happening right this minute. And the training programs so far are related to things very specific to COVID in most cases. Food service and social distancing, CDL, certified electrical technician, telehealth, programmatic logic controllers, supply chain logistics, and IT systems such as security and other IT programs. So we've got good traction with the skills funding. Approximately $4 million in TANF funding was approved for local workforce development boards, primarily to hire staff. As you know, the majority of the local employment specialist staff have been repurposed for a very long period to help with the rush of unemployment insurance claimant needs that we had. So you all approved funding primarily for local boards to staff up. And with that, at least 81 staff have been or will be hired. And what those staff primarily do at the local level are work with employers to provide information about COVID grants that are available, and also help them with their training needs, help them to get their jobs posted, help with information about bonding and work opportunity tax credits and other credits. In addition, those staff help job seekers. It is very common that they will be making taking and making phone calls to job seekers, helping them to update their resumes, get them registered and work in Texas, talking about labor market information as things change in our state, and helping to make the connection between employers and job seekers. A portion of the fund is used to expand or purchase or expand their licenses so that they can provide more customer service virtually. Almost everyone we work with as a grantee has needed to use some amount of funding to expand services. Our boards with some of the TANF dollars have expanded online chat to make services available for longer periods of time during the day for people that have questions. They've also offered job readiness workshops, which I'll talk a little bit more in a minute, and software for hiring events. Next, I will provide an update on the use of the Wioa funding. And as I described the workshops and some of the software, it's very similar to the use of the TANF funds that I just described. So I thought I would just go through the laundry list here. But the same type of topics have been provided covered both with the TANF dollars and Wioa. So commissioners, you approved $12 million in Wioa funding on the 14th of April. And to date, $6.4 million of that is awarded in 14 grants to workforce boards. 4,750 Texans will be served in rapid response activities with these dollars, meaning that through rapid response, laid off workers are visited by our staff, unemployment insurance, and our staff, and they'll provide services to help reconnect them to the workforce system. And that may look like invitations to different events happening, hiring events, or other events happening at the Workforce Solutions offices, providing them with job leads, and then giving them a little bit of counseling on the steps they're going to want to take to ready themselves for the next job. 1,360 workers will be supported through layoff aversion activities. And what that normally looks like is our staff work with employers and provide some type of financial support, counseling and financial support to employers to help them financially and allowing them to maintain their current workforce. So that through layoff aversion, we're really able to meet some specific, often COVID-related needs for an employer and help curb some costs for them. More than $3.7 million has been granted to support 103,000 people who will receive different workforce services, either through online platforms or learning management systems. And what that looks like is that the platforms may train customers in job readiness skills. These are the classes I was going to go into some more detail about. Resume writing, interviewing skills using new technologies. A lot of people haven't interviewed in a long time, and in this new world, they need to know more about the systems that they're going to be interfacing with. The boards also are using these virtual platforms to teach interviewing with background issues, how to answer those tough questions in an interview, how to put your best foot forward, even though there's something that you do need to disclose to an employer. Career planning and goal setting in the new labor market, financial responsibility, specifically for, well, anyone who needs financial help, financial counseling, or financial responsibility help, but also for those who are not accustomed to living maybe with unemployment insurance or a lower amount of funding. Most boards are offering some type of financial responsibility and financial knowledge course at this point, and being able to do that virtually allows them to reach more people. $2.5 million of the Wioa dollars were for technology for hiring events specifically, virtual tools that allow them to both onboard the employers and the job seekers electronically without having to bring people into the office. And learning management systems and technology hubs were something that we've seen boards have a great interest in right now. And basically those systems build a platform for a person to come in and be able to navigate the system, find support service referrals or other community resources in one place as in the board's website, bringing things together for customers. Last, I'll mention that the Wioa funds are used to support training in areas like supply chain management, health safety and OSHA, HAZWOPER, cybersecurity, warehouse management, medical coding. With the funds awarded to date, 5,000 Texans will receive training with those funds through July 2020. Obviously, like I mentioned earlier, the training goes beyond July, but just to give you an idea of what's happening right now, by the end of July, we'll have 5,000 trained in one of those topics. I'm happy to answer any questions about the funding.
Comments or questions?
Chairman, I have a few. Thank you, Courtney, for the report, and thank you for working closely with all the offices to update us on the activity. So you reference boards are applying, have initiatives going out there, have planned projects. Are all 28 boards participating in some type of activity?
That is correct. All boards are providing services virtually, or some are still providing a limited amount of in-person services, but all boards are providing those services, including workshops.
So I want to take this time to applaud them. They're doing great work, and we've been able to, through social media, follow them, so we're very grateful to them. I also want to keep in mind that as you were reporting and giving us updates, I also want to keep in mind that we focus on those individuals that are coming out of, that have been dislocated as a result of agricultural, cuts, the farm workers that unfortunately are out of work or displaced. You were talking about being able to provide them with certifications, distance learning. This is a great group to focus on. And another group that I would ask that our boards look at, and I'm sure they are, is individuals that have been released from our prisons. We're seeing more and more folks that are being released, especially during this time. And then, of course, let's keep in mind that we still have, regardless of where you live in Texas, we still have the digital divide. And so the distance learning, being able to provide them with the equipment needed to successfully complete the programs is important to, I think, everyone. The infrastructure, the broadband service, and maybe hotspots. Being creative as possible, I think, is very important. So I want to take this opportunity to thank you. I know we've worked with you and Dale during this whole process, so thank you for that, Courtney. And I would encourage you to continue asking the boards to be as creative as possible. They know that I've always encouraged them to think outside the box, so thank you for that.
Mr. Chairman, Courtney, at the end of the month, I'd love to make sure that we have a report that gives us the remaining balances that are due, that are outstanding. I think adult ed, the first one, again, tell me how much we approved for that and how much we have right now, what's remaining in adult ed.
Commissioner, I'm sorry, I wasn't able to hear that last statement or question.
The adult ed, you started out with adult ed, the amount that we funded with adult ed and what's remaining with adult ed.
I'm so sorry, it's not coming through clear.
That's okay. You had 167,000 licenses, I think you were reporting out. And so I'm just asking for the remaining amount under adult ed. How much we approved and what's our remaining amount? And if you don't have that now, don't worry. I'll get that later on ed. So what I want.
Is it okay? Is it all right if I bring you that update, sir?
Yeah, that's fine.
Okay.
That's fine. So it basically, the amounts that we funded and the amounts that are remaining are very important. And so I also want to commend the skills team for what they're doing. She mentioned $10 million and about $6 million of those dollars that are spent And so we have about 4 million that's remaining there. And that's, congratulations to that team for getting that money out of the door. And then the boards and what they're doing, again, it looks like we're moving that money in those activities, but I'm really interested in making sure that that funding is either fully utilized and or we bring it back and use it in other ways that could be of a benefit.
Yeah, I agree with you, Commissioner. The boards are doing exceptional work right now during this time, so, and I'm glad that they're working closely with Dale.
Yeah,
Dale's doing a great job.
making it happen.
Elevated the game.
Thank you.
Courtney,
Yes.
you've outlined, I think, very, very well how boards have adapted to the situation that we find ourselves in, and they're doing a number of things, in fact, many, many things to help in their region, what's important in that region. And I guess that's a long way of saying, you know, I think that the local approach that we're able to bring through Workforce Solutions is often a good approach. But like Commissioner Demerson, I am a little bit focused on unexpended balances, and let me lay this out like this, because I want you to understand I'm coming at this from a place of we've done a lot of things. We've been working very, very hard. We're helping a number of people. If you look at skills development, 6 of 10 million has been allocated at this point. I looked through that list of potential recipients. It is very geographically diverse across the state. Many, many different community colleges are participating. Some workforce boards are participating under their new eligibility. I think that while that's moving slowly, in my opinion, I think that they're definitely moving toward something that's going to be very, very helpful to people during this time. And so, you know, the progress there hopefully can speed up, and we can get the remainder of that 10 million expended for this purpose. But as Commissioner Demerson has alluded to, you know, we can come back in a week or two and take another look at that and try to understand where we are. AEL dollars, very pleased to hear how that's being expended. The TANF dollars, I think, are going to a very good use. Let me settle back in on the Wioa dollars that we pulled down out of commission reserve funds and some other things to push out there. Based on what I just heard you say, we've spent about 6.4 million of an available 12.8 million. Did I get that right from your report?
6.4 has been awarded of the Wioa funding. That's correct. And it was 12 million available.
Yeah. I think I have some similar concerns to Commissioner Demerson's. I think his view here might be a little longer than mine. I intend today to offer a motion to halt funding on applications that haven't been received and or approved as of today, to give staff time to look at the remaining 6.4 million. Bring us a plan. Our next commission meeting is 2 weeks from today. Bring us a plan for an alternative funding program where we might provide training opportunities for all Texans who are on unemployment during this time from the state level, so that we can speed that up and scale it statewide, with the intention that all board areas would be able to participate, but that would be coordinated here at the state level. Now, I have not offered that motion as of this moment. I intend to momentarily, but certainly it would be appropriate at this time to hear from my fellow commissioners. If there's any serious objections to this, I want to talk through it here today, but my intent is to offer this motion and hopefully give us a chance to look at this a little different. Sometimes I think we get locked into a model. Our models typically work, but my goodness, so many different things going on these days. I want to make sure that we're serving all Texans that can be served here. So, Commissioners, I would really appreciate your input. I'm perfectly prepared to offer the motion, but I don't want to, I don't want to rush this, and I think I'm coming at this logically, but perhaps you could shed some light on your feelings on the subject.
Chairman, I totally agree with you. I'm in support of and in agreement on your remarks just made, so no objection here.
Yeah, I think it can make sense. I like us to, and I think you mentioned this, whatever we have in the pipeline, making sure that that's taken care of, and if it's 6.4, if it's something else or whatever, going back and making sure that whatever we've committed to, that's allocated, and then as of a go-forward basis, that way we're not jerking anybody out of something that they're midway or whatever, but coming up with whatever that dollar amount is and where they are, and with the caveat that if there's something midstream or something, that we're in a position to not have an unintended consequence of our action. And I think if staff's able to do that, we're in a position, Mr. Chair, to move forward.
Commissioner, we're of like mind. I don't want to short circuit something that's going on that could be beneficial. But by the same token, government's not known for being nimble, and I'm trying to introduce some nimbleness
great.
to our response. Here's my motion then. I move that.
Chairman, before you make your motion, there is one thing I'd like to just jump on on what Dale and his team do. You know, when we train folks, and I'm sure we're all in agreement, we do it for long term. So I just want to make sure that when we implement these types of training models, that these are for long term. You know, it's not just something that's going to be for 6 weeks and it's gone. And I think you would all agree that just we'd follow the same training programs that we do for upskilling, I guess I would say, that we're doing. And I know we've referenced that multiple times from the dais, but I totally agree with what you've said, and I look forward to your motion, Chairman.
Yeah, I mean, to that point, I certainly, nothing in my motion is going to impact where we are with skills development. While that model operates slowly, and I don't mind saying that, I would love to speed that up a little bit. The underlying foundation of that program works very, very well.
Yes.
It's a local community college, oftentimes a local workforce board, serving local folks, and traditionally, you know, a local employer that's able to expand job offerings in the area. That particular program, I want to see how it develops on this COVID response for a few more weeks. I do anticipate that there may be some additional dollars there, and we may want to look at something related to upskilling, but I think that's premature at this point.
Okay.
I want to, before I offer this motion, I do want to address something that you said, and I think that we have been for some time talking about this in our commission meetings, which is this notion of upskilling. This is a time when I think that we can really bring some resources to bear on this in an important way. This idea that if you analyze who has filed initial unemployment claims, you're going to see a lot of folks that are in hourly jobs that are move and fluctuate quite a bit in the marketplace all the time. Certainly during this time, it's a downward fluctuation, and I'm looking at solutions for that long term. Before February of this year, a primary topic of conversation that I dealt with out and about as I traveled and visited with different groups was this notion of a gap in middle skills employees, people who were eligible, maybe not eligible, but certainly trained and ready to go in middle skills jobs. And I'm viewing this as an opportunity to help some folks who are sort of temporarily out of the workforce, maybe out of a low wage, hourly wage job that didn't necessarily have any kind of advancement potential, and give them an opportunity to find some training that will help when they re-enter the workforce, perhaps back to that job. If that's a job they love, I hope that they're able to go back to that. But certainly if they want to use this as an opportunity to upskill. And I think that really the essence of my motion is that we took this money out of commission reserve funds to make it available. It's been out there for 45 days. I think folks who have needed it have filed applications to access that money. I'm suggesting we bring it back to commission reserve, let staff give us a plan. Next meeting, 2 weeks from today, we'll decide what's the best way for us to proceed forward. To your point, where I'm headed the long way around is I don't like just short-term, one-time solutions. I'm looking for some longevity. Over time, this agency has built good opportunities for people to access training, Skills Development Fund being foremost among those. The folks who have headed that up and led that effort and sort of pushed that effort out there have done a good job. I just want us to keep pushing. I think there's some opportunity for innovation here.
Yeah, no, I agree. I think our Texas employers, it's an opportunity. If we have a skilled labor force, workforce, we're in a position to move forward. So anything we can do to be flexible, nimble, creative along those lines. We talk about mentornships, internships, returnships, all of those things that are out there. And if we're training towards that, allowing other individuals opportunities, that's a benefit for our Texas employers.
So my motion would be as follows. I move we halt funding board applications from the approved $12,856,131 COVID response Wioa funds that have not been requested and approved as of June 2nd, 2020, and instruct staff to come back during the next commission meeting, which is on June 16th, 2020, with an alternative plan to use the remaining balance to fund projects that provide rapid training to upskill eligible unemployed Texans.
Great motion, and I agree to that.
Motion's been second.
I'll second that.
Okay. I'm in favor.
Okay, so show
Unanimous.
us as unanimous on the motion. We've got the motion now memorialized. Courtney, functionally, bring us a plan, let us look at that. We'll make some kind of final decision at the next commission meeting, which is on June 16th.
Okay, will do.
Thank you so very much.
Thank you.
I had nothing else, sir.
Thank you, Mr. Cerna. All right. Then that'll take us to Tom for a legislative report.
Good morning, Chairman Daniel, Commissioner Alvarez, Commissioner Dimerson, Tom McCarty with External Relations. Last Thursday, the U.S. House passed H.R. 7010, the Paycheck Protection Program Flexibility Act of 2020. This bill would give companies more time to spend dollars that they received under the program. This would extend it up to 24 weeks or until the end of the year, whichever came first. And this would still allow them to have loans forgiven. Businesses would also have up to 5 years instead of 2 years to repay any monies received, any money owed on a loan, and could use a greater percentage of proceeds on rent and other approved non-payroll expenses. The U.S. Senate will consider this legislation. Yesterday, Congressman Brady introduced the Reopening American by Supporting Workers and Business Act of 2020. The bill would allow workers to keep up to 2 weeks of the supplemental federal unemployment benefits. This is the extra $600 per week that claimants receive after accepting a job. The bill would also address program integrity issues by ensuring that employers can report job refusals and ensure states provide clear notice to unemployment claimants about return to work obligations and good cause exceptions. And then finally, the bill would provide additional relief to reimbursing employers by clarifying that they do not need to pay the entire amount of their obligations and wait for reimbursements. Instead, states can reduce the amount of the obligation up front. The bill has yet to be assigned a bill number, and no timetable for consideration has been announced. This concludes my remarks, and I'm happy to answer any questions you may have.
Questions or comments?
No, Chairman.
None here.
Thank you.
Thank you.
Mr. Cerna?
No other updates, sir.
Thank you very much. Commissioners, any additional business or announcements?
Chairman, if I may, I'd like to introduce to everyone James Sutton, who's sitting in the front row, waving his hand. James, could you stand? I was just kidding. We're very welcome. We're very privileged and honored to have James starting with us. He started with us Monday. His work product, his experience, his attention to detail, we're very impressed with. But I have to commend Sherry Miller for that. I think her team and the product that she produces and allows us to work with, I'd be remiss if I didn't acknowledge the great folks that she has working for her, and we're very fortunate that James comes from her office or her area and is now working with us. So we're very glad to have him here. So James, congratulations.
Welcome on board, James. I was looking at him thinking, he already works here. Where is he? We're Sherry's team. Congratulations and welcome.
Yes. Then, Chairman, I have something else, if I may. I want to thank you, Chairman, and also Commissioner Demerson. Today, I'm privileged and honored to be acknowledging the 100th anniversary of the Vocational Rehabilitation Program. This program, obviously on June 2nd, 1920, President Woodrow Wilson signed the Smith-Fess Act into law, also known as the National Civilian Rehabilitation Act. The program served individuals with disabilities, providing job placement, counseling, and training, and prosthetics. In 1936, Congress passed the Randolph-Shepard Act to meet employment needs of individuals with blindness, established preference for vendors who are blind to operate vending and dining facilities on federal property. And in 1938, Congress passed the Wagner-O'Day Act, which required the federal government to purchase goods from nonprofits that employed 75% of blind workers. Today, the federal program is known as the Ability One. With that, I am honored to acknowledge today the 100th anniversary today, the actual day today, June 2nd, as the anniversary of the Vocational Rehabilitation Program. So I want to take this opportunity to thank them, and of course, Ms. Fuller and her team for all the great work that they do.
Commissioner Alvarez, thanks for bringing that up.
No question that that's been a beneficial program for, 100
Yes, sir.
years now. And any kind of program with that kind of longevity, I think's proved its value, and I'm certainly confident that our vocational rehabilitation team here at TWC will, as we enter the next 100 years, will continue to innovate and make that useful and helpful to so many Texans.
I agree.
Are there any other announcements or other order of business which should come before the commission? None. Do we have a motion to adjourn?
Chairman, I move that we adjourn.
I second that motion.
It's been moved and seconded to adjourn, and we're adjourned.